Hello friends, I'm Sanjay. In this series, I'm solving and explaining the CLAT PG 2024 question paper from the exam that was conducted in December 2023. This is part 4 of the series and I will cover the fourth passage and the 5 MCQs associated with it. You should watch this series from part 1 onwards, in which I have given a brief overview of the approach that I'm taking with this paper and also why the elimination strategy is very important in this exam. This fourth passage is based on a 2011 case that deals with the subject of promissory estoppel against the government. Promissory estoppel is a legal principle which is used in contract law that allows a party to recover on a promise, even in the absence of a formal contract, under certain circumstances. For example, A is a house owner and B is a painter. A tells B that he wants to get his house painted. B inspects the house, prepares an estimate for the work that is required and how much it will cost. A says that he is happy with the estimate and asks B to come on Monday morning to begin work and also to get everything that he needs. Here, there was no written contract, only a verbal confirmation or a promise that B has the job. B believes in A and buys the paints and other materials he will need to do the job. On Monday morning, when he comes to begin his work, A tells him that he has changed his mind and he does not want to get his house painted anymore. Given that B believed in A's assurances or promises and already spent money on the material that was required for the job, he can approach the court for a promissory estoppel. The court can then compel A to repay the costs of the material and any other expenses incurred by B. The court will not compel A to get the house painted, but only to ensure that B does not suffer any losses as a result of A's promises. In this specific case, the subject of how and when a promissory estoppel can be enforced against the government is dealt with, and also under what circumstances the government can rescind its promises. That is, what are the exceptions to this principle of promissory estoppel. Question number 16 is asking that the decision in this case carves out or creates a public interest exception in cases of promissory estoppel against the government. To what kind of cases have the courts routinely applied this exception in favor of governments? If we think about it logically, if the government is making some promises, what kind of promises do governments routinely make to businesses in general? It can either be to provide some tax incentives, some subsidies, some grants or loans. All of these are ultimately money related, that is, fiscal matters. Very rarely can there be any service matters or labor matters. Even service or labor matters, for that matter, are ultimately about money. So they are all fiscal matters. Which means that the promissory estoppel cases that come up in courts will be routinely about fiscal matters, and therefore the courts will routinely apply this public interest exception in such fiscal matter related cases. So, by just using a little bit of logic, we can directly answer this question. I have also marked this as a contextual question because if you read through the source judgment, the court has specifically spoken about the exception in the context of fiscal statutes and fiscal benefits. Question number 17 is a completely external question, which requires you to be aware of some landmark cases on promissory estoppel against governments. The correct answer here is option B, that is the Motilal Padampat case. This is not a contextual question because this case is not mentioned in the source judgment from where this passage has been taken. There are several other cases mentioned in the judgment, but not the answer to this question. And if you are not aware of the correct answer and you had to take a guess, then eliminate the obviously incorrect options like the Carlyle versus Carbolic Smoke Ball Company case and any other cases that you can rule out and guess from among the remaining options. Question number 18 is a direct question and a simple question. It is asking us to identify the correct statement from among the given options. The correct answer here is option B. The complete correct answer is directly mentioned in the passage. So this is an easy one. The one trick that I want to mention here is to focus on some keyword or phrase or number while searching through the entire passage. Here, Article 299 is a good flag, using which we can quickly scan through the passage and see where and how it is mentioned. And the correct answer for the related question can usually be found around that part of the passage. For example, Article 299 is mentioned here in the first part of the passage, and the correct answer is also found here. 19 is asking us to identify the correct or accurate statement. Let us start with option C. Permitting a public interest exception is against the interests of justice, equity and good conscience, as it is a self-serving claim for the government. This is not correct, because everything that the government does is supposed to be in the interest of the country, in the interest of the public, and genuine public interest cannot be a self-serving claim by the government. If it is a misuse of power or if it is for illegal reasons, then such actions will be against public interest. But if the actions are genuinely within the law and in public interest, it cannot be called self-serving. So this statement itself is wrong. Option B, the doctrine of promissory estoppel overrides any purported claims of public interest by the government. This is also wrong, because if there is a genuine public interest at stake, it will override promissory estoppel and not the other way around. The doctrine of promissory estoppel stands diluted, where the government claims that it is in the public interest to go back on its promise or actions. This statement is correct. It is also supported by the passage here, and public interest is one of the exceptions against enforcing promissory estoppel against the government. Question number 20 is asking which of the following statements does not reflect the correct position of law. That is, which of the options is incorrect. Make sure that you read the question properly. This question is not asking us to identify the correct statement, but to identify the incorrect statement. Promissory estoppel cannot be invoked so as to defeat the law. This is a correct statement, because the courts cannot enforce a promissory estoppel if such an enforcement results in violating any applicable law. Even if the representation is made by the government itself, but it goes against the law, estoppel can be invoked to defeat the law. This is incorrect. Here it should have been cannot be invoked to defeat the law, because even the government cannot violate the law. If required, it can duly change the law, but the current laws should not be violated. If all the conditions of promissory estoppel are met, a challenge can still be made to the wires of the law. This is a correct statement, because even if all the other conditions are as per law, that doesn't prevent a person with valid reasons from questioning the law itself. Since the objective here was to identify the incorrect statement, the answer is option B. In the next part of the series, I will cover passage 5 and the associated questions. I would recommend that you should read the passage, the source, and also attempt the 5 questions on your own, so that you can more easily follow our conversation. You can also go to lawmen.com and check out the CLAT PG mock test series for the next exam, which includes all the CLAT PG previous papers, including this one, and also both new and old pattern mock tests for CLAT PG and other LLM entrance preparation. You can also attempt a free full-length mock test to get a feel of the series. I will see you soon in the next video. Jai Hind.